Everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with a brief update on the Tim Norman case. You know, as they move closer and closer to actually taking this case to trial, we'll see more and more motions being filed and more tactics by Tim Norman to delay the trial. So far, nothing he's tried has really worked, but he's still at it. And then I was also thinking about his co-defendants. I am going to come to the conclusion that his co-defendants are going to turn on him, that they are going to testify against him in order to get a lesser sentence. Because when I tell you they have not filed any motions, like they are basically just sitting back, chilling, waiting on Tim to cut out the foolishness so that they can go to trial, lets me know that they have probably gotten deals with the government to testify against Tim. But before we get into this update, because there really hasn't been much going on, but there has been a little movement. We all know that today is April 1st, which is April Fool's Day. And so one of my friends, who's probably watching this video now, so yeah, girl, I'm shouting you out right now. I'm not going to call you by name. But she sends me a text this morning, and it's talking about R. Kelly and the fact that he had been released on an appeals bond. And so she sent me the screenshot, and she was like, is this true? And so I looked at it, and I'm like, I don't think so, because for one, his attorney, Jennifer Bonjean, has not entered a motion for an appeals bond. And furthermore, he is still in the post-trial motions as far as trying to get the trial, either getting a new trial or having the judge toss the verdicts altogether. So he hasn't even really gotten to the appeals, like the true appeals process. And so she replies back to me, and then a few minutes later, she comes back with another screenshot. So evidently, some YouTuber by the name of Choke No Joke, I guess thought it would be funny to put out this thing saying that Mr. Kelly had been granted a bond and was home. And of course, Mr. Kelly's supporters did not find the humor in that. And so it just goes to let you know that everybody that claims to be for the man is not for the man. And that was, to me, that was just a really tacky joke. But anyway, we're going to go ahead and get into this Tim Norman case. And so several months ago, I had downloaded this information, and I was going to do some research on it and got sidetracked. And so this was a motion that Tim filed, and he was trying to suppress evidence in his case. And it says, comes now the United States of America by and through its attorneys, Sailor A. Fleming, United States Attorney for the Eastern District of Missouri, and Angie E. Danis and Gwendolyn E. Carroll, Assistant United States Attorneys for said district, and for its response to defendant's motion to suppress evidence, states as follows: procedural and factual background. On or about August 11, 2020, James Timothy Norman, hereinafter referred to as the defendant, was charged by way of suppressed criminal complaint with violations of Title 18 United States Code, Section 1958, conspiracy to use a facility of interstate commerce in the commission of a murder for hire, resulting in the death of defendant's nephew, Andre Montgomery, on March 14, 2016. In conjunction with the suppressed criminal complaint, an arrest warrant was issued for Norman on August 11, 2020. And if you're new to this channel and have no idea who James Timothy Norman is, he is the son of Robbie Montgomery, who was a former backup singer for Ike and Tina Turner. And most recently, she had a show on the OWN network, which is the Oprah Winfrey Network. And so she has some soul food restaurants in St. Louis, Missouri called Sweetie Pies. And Oprah did a reality show on Miss Robbie and her family called Welcome to Sweetie Pies. And so Andre Montgomery joined the cast midway, I think, through the run of the show, and he was ultimately murdered on March 14, 2016. And now Miss Robbie's son, Tim, who was also on the show, along with 3 other people, have been charged with that murder in federal court. So it says on August 18, 2020. Oh, and by the way, if you want to get caught up, I will tag some of the videos up above, and you can go and watch those so you can get the backstory and more information. So on August 18, 2020, agents from the Federal Bureau of Investigation St. Louis office coordinated with FBI agents in Jackson, Mississippi, and police officers with the St. Louis Metropolitan Police Department to effect the arrest of Norman at his residence located at 213 Rampart Street, Ridgeland, Mississippi. Approximately 11 law enforcement officers were present to assist in Norman's apprehension. Special Agent Christopher Farber, hereinafter S.A. Farber, would testify at the evidentiary hearing that Norman emerged peacefully from his residence and was taken into custody with no resistance. Norman advised that there were no other individuals located in the residence. At the time he was taken into custody, Norman was wearing a t-shirt and athletic shorts. When law enforcement officers searched Norman incident to his arrest, a cellular telephone was located in the pocket of his shorts. Norman then signed a property receipt acknowledging that S.A. Farber had seized said cellular telephone from him, which is attached as Exhibit 1. To this response, no other items were seized from Norman. S.A. Farber will testify that no member of the arrest team ever entered Norman's residence, nor did they acquire any evidence therein. The government will offer further evidence in support of S.A. Farber's testimony. Following his arrest, Norman was confined in the Jackson County Jail until he was transferred to Missouri. Norman made multiple phone calls that were recorded via the jail's phone monitoring system. In a call made to an unidentified male on August 24, 2020, Norman stated the following, beginning at the 4-minute and 20-second timestamp. They bang on the door. I open it. There's 7 motherfuckers and machine guns pointing in my face. They take me in, man. I ain't got nothing but my gym shorts, my fucking phone, and a tank top on. In another recorded call on August 24, 2020, to an unidentified female, Norman stated the following, beginning at the 2-minute and 30-second timestamp. I ain't even had enough time to fucking turn my phone on live or record. None of that shit. Just hands up. So they just took me. I had on my gym shorts, my fucking tank top, and my phone and my flip-flops. They fucking just took me. The government intends to offer transcripts of these 2 calls in addition to the audio recordings themselves at the evidentiary hearing in support of S.A. Farber's testimony. On September 2, 2020, S.A. Farber applied for and was granted a search warrant for the contents of Norman's cellular telephone. The search warrant was signed by the Honorable Judge M. Bodenheiser under cause number 420 MJ 1182 JMB. A subsequent search yielded incriminating evidence against Norman and his co-conspirators, which is the subject of Norman's motion to suppress. So the legal argument, Norman's invocation of the exclusionary rule as to the results of a search of his cellular device is based solely on its alleged unlawful seizure. However, Norman has no evidence that the seizure of his cellular telephone occurred in any other manner than that described above and as S.A. Farber will testify to at the evidentiary hearing. Norman cannot produce any credible evidence to support his contentions that the law enforcement agent searched his residence upon his arrest on August 18, 2020. As the evidence will demonstrate, Norman's cellular phone was located in his pocket during a search incident to his lawful arrest. When an arrest is made, it is reasonable for the arresting officer to search the person arrested in order to remove any weapons that the latter might seek to use in order to resist arrest affect his escape. Otherwise, the officer's safety might well be endangered and the arrest itself frustrated. In addition, it is entirely reasonable for the arresting officer to search for and seize any evidence on the arrestee's person in order to prevent its concealment or destruction. And then that was a quote from the United States versus Robinson, a case that was heard in 1973, and also quoting Chimmel versus California, which was a case heard in 1969. And then they also cite some other cases that were quoted as saying, one in particular, United States versus Mendoza, which was in the 8th Circuit in 2005, affirming as lawful the search of the defendant's person and seizure of his cell phone as a valid search incident to a lawful arrest. And then that was citing United States versus Oakley, 8th Circuit, 1998. The justification or reason for the authority to search incident to a lawful arrest rests quite as much on the need to disarm the suspect in order to take him into custody as it does on the need to preserve evidence on his person for later use at trial. And that's from Angelello versus United States, a case that was heard in the 1960s. And then the conclusion, wherefore, as the overwhelming weight of the evidence establishes that Norman's cellular telephone was lawfully seized and a search warrant was obtained to examine the contents of said cellular telephone, defendant's motion to suppress should be denied. The government respectfully requests this court enter an order consistent with the foregoing. And that was from Sailor Fleming, United States Attorney. And so you guys know that Tim was out of line for even filing a motion trying to get them to suppress that phone. And then they showed the property receipt where they took it in, and basically just says it was an iPhone case and an Apple iPhone that was gold in color. And so why Tim thinks that they should turn that phone over to him and that it should be suppressed is beyond me. And so there's been a couple of other evidentiary hearings that have taken place throughout the past couple of months. The most recent one was on March 25th, and then we'll get into what happened there. Okay, so then there was a hearing that was held March 25th, and it basically was talking about the evidence and that type of thing. And the government filed a motion to prevent or prohibit Tim Norman from calling one of the, I want to say it was one of the detectives at the evidentiary hearing for the sole purpose of impeachment. But I'm going to, before I get into that, because it is a lengthy document, I am going to go over this list of exhibits that I guess they plan to present at trial once they eventually get there. And so there is an arrest warrant for Tim, a photograph of his house, which is 213 Rampart, the black and gold iPhone seized from Tim when he was arrested, which I just read to you guys that he's trying to get back. The St. Louis Police Department evidence envelope containing Norman's phone, FBI envelope with S.A. Farber's writing containing Norman's phone, FBI property receipt for Norman's phone, a disc containing the full jail calls from which Exhibits 7 and 8 were extracted, and that was what I just read to you all. And then excerpted clip from call on 8/24/20 with Norman to an unidentified male. And then a transcript from that call, affidavit of Madison County Jail custodian, excerpted clip from call of 8/24/20 from Norman to an unidentified female, which I just read to you all, and then a transcript of that call, and then the search warrant for Tim Norman's phone. So ain't no telling what kind of juicy information is on that phone. So let's go ahead and let's get into Tim trying to get this detective to testify. So it says, come now, the United States of America, by and through its attorneys, Sailor A. Fleming, United States Attorney for the Eastern District of Missouri. Hey, hold on a second. Okay. And Angie E. Dennis and Gwendolyn Carroll, Assistant United States Attorneys for said district, and for its motion in limine and to prohibit defendant Norman from calling Detective David Rudolph as an evidentiary hearing witness for the sole purpose of impeachment. The government states as follows: on December 23rd, 2021, defendant Norman filed a motion to suppress evidence with the sole issue involving the seizure of Norman's cellular telephone on August 18, 2021, the date of Norman's arrest on charges for conspiracy to commit a murder for hire. Now, I thought Tim was arrested in 2020. They got 2021, which would just been a few months ago, so I'm not sure if that is correct. It says Special Agent Christopher Farber from the Federal Bureau of Investigations will testify that he seized Norman's cellular telephone from Norman's pocket. Ooh, child, I don't know who typed this here. It says will testify that he seized Norman's cellular telephone from the pocket of Norman's during a search incident to arrest. I think they should have just said from Norman's pocket. So it says Special Agent Farber then obtained a search warrant for the contents of Norman's cellular telephone and conveyed the phone to the Cybercrimes Division of the St. Louis Metropolitan Police Department, where a forensic example was completed, and they will further refer to the St. Louis Metropolitan Police Department by its initials. On March 1st, 2022, the St. Louis Metropolitan Police Department homicide detective David Rudolph was served with a subpoena from counsel for defendant Norman. Detective Rudolph did not witness the seizure of Norman's cellular telephone on August 18, 2021, and only came into contact with Norman after he had been secured in custody and searched by Special Agent Farber. As such, Detective Rudolph would have no relevant testimony to provide regarding the seizure of Norman's cellular telephone, the sole basis of the pending motion to suppress. As he has no relevant testimony regarding the seizure of Norman's cellular device, the government can only surmise that the sole purpose in defendant Norman calling Detective Rudolph to testify at the evidentiary hearing would be to impeach Detective Rudolph with allegations stemming from a lawsuit filed in 2015 against Detective Rudolph and others. A. Law regarding impeachment of one's own witness. It is improper to call a witness for the sole purpose of getting otherwise inadmissible evidence before the jury or judge in the guise of impeachment. United States versus Buffalo, which was heard in the 8th Circuit in 2004. Although Rule 607 allows a party to impeach his own witness, courts must be watchful that impeachment is not used as a subterfuge to place otherwise inadmissible hearsay before the jury. United States versus Fay, 8th Circuit, 1981. Federal Rules of Evidence 607, quoting United States versus Rogers of the 8th Circuit, 1976, citing United States versus Morlang, which was heard in the 4th Circuit in 1975, holding it has never been the rule that a party may call a witness where his testimony is known to be adverse for the purpose of impeaching him. This type of evidence is also impermissible under the Federal Rule of Evidence 404A and does not fall within the exceptions set forth in Federal Rules of Evidence 607, 608, and 609. While the rules of evidence may not apply in evidentiary hearings, the court has wide discretion in determining what does or does not come in. If this were not the case, no objection lodged during evidentiary hearings would ever be sustained. B. Background regarding Detective Rudolph. In 2015, Detective Rudolph was named in a lawsuit that alleged various constitutional rights violations on behalf of a robbery suspect. This lawsuit was brought before District Court Judge John A. Ross of the Eastern District of Missouri under case number, and then is 4:15-CV-01315-JAR if anyone wants to look that up and get more information. One of the allegations brought forth during the lawsuit was that Detective Rudolph and others intentionally destroyed a cellular telephone that may contain exculpatory evidence, and that they willfully ignored evidence of the robbery suspect's innocence in pursuit of their investigation. McKay versus City of St. Louis, which was appealed to the 8th Circuit in 2020. As evidenced by Judge Ross's granting of Detective Rudolph's motion for summary judgment, which was affirmed on appeal, these allegations were without evidence or merit. As noted by the Court of Appeals, McKay conceded there was no evidence that Doe's phone was intentionally destroyed, let alone destroyed in bad faith by or on behalf of the police defendants. Judge Ross's original order granting summary judgment on behalf of Detective Rudolph and several other defendants in said lawsuit is attached as Exhibit 1 to this motion, and the appellate decision affirming Judge Ross's order is attached as Exhibit 2. C. Argument. Admittedly, counsel for the government cannot be certain that this is the intended line of questioning for Detective Rudolph, as counsel for defendant Norman, who subpoenaed Detective Rudolph for purposes of this evidentiary hearing, has not indicated why he intends to offer Detective Rudolph's testimony. However, as Detective Rudolph was not involved in the seizure of defendant Norman's cellular telephone, which is the only issue before the court for the purposes of the evidentiary hearing, the government can surmise that their intention is solely to impeach Detective Rudolph's character. Wherefore, the United States of America respectfully requests that this court enter an order in limine consistent with the foregoing and prohibit defendant Norman from calling Detective Rudolph as a witness for the sole purpose of impeaching him. And so I think I said above that the judge had denied Tim's request to get the phone back. So all of this evidentiary hearing that took place on March 25th was concerning the whole phone situation. And I don't believe that the judge has made the ruling, but I'm 99.9% sure that she's going to tell Tim to go and kick rocks. And so the vast majority here, it talks about the case. This document was like 28 pages long, and it is talking about the case that Rudolph previously was a part of. And based on the information that they've given in this motion, I am so confused as to what it is that Tim is trying to prove here. If this particular police officer did not witness the seizure of the phone, like it was the FBI agent who took the phone from Tim. So I am just like really lost as to why Tim is wasting tax dollar money in trying to delay this trial. He can't delay the trial indefinitely. So why is he wasting taxpayer dollars? And what was on the phone? Like, is there something that is going to come out in trial about what was on that phone, because according to the evidence list that I read to you all they were really concerned about was those 2 conversations that he had with people that he contacted while he was in holding. So exactly what is the point here other than trying to delay the trial, which he is so crazy. Anyway, guys, that's the update on the Tim Norman case. Like I told you, nothing much is going on. Tim is just at the phase where it is time for this case to go to trial, and I think that the judge and the prosecutors are becoming weary. He's wearing them down with all these motions, and I could see if they were motions that had merit. But none of the motions that he's filing has any merit, and they're just tossing them back to him. And I think that the judge was pretty good the latter part of last year, giving him more time. I think there was an incident where there was a COVID outbreak at the prison, and they had to delay some hearings, or they had to do the hearings via Zoom because he had been exposed to COVID. I'm not sure if he caught COVID, but definitely there was an outbreak at the prison, and so they did the hearings via video conference. So they're ready to move forward with this. The other defendants are patiently waiting. I mean, they probably already accepted deals, as I said earlier, and they're just waiting to go and testify against Tim, because Tim is the only one that is filing these motions and trying to postpone this case for as long as he can. And I told you guys that the Gloria Rodriguez lady has joined his legal team. And then before I go, it was one other thing I want to talk about. People were talking about Tim. His 2 original attorneys had taken out PPP loans, and the amounts of the PPP loan shows that they're not good attorneys and they aren't making that much money. And I just want to say that PPP loans are payroll protection loans. The payroll protection loans was to pay your employees during COVID because the business may not have been making that much money. And so the attorneys and it's only for 2 months worth of payroll, I believe it was. So if the attorney, I think one attorney had like $30,000 in PP loans, and the other attorney had like $100,000 and some in PPP loans, that meant that is the amount that totaled 2.5 months, I believe it is, 2 months or 2.5 months of payroll for all of their employees. That's what those loans are based on. And then also there were other loans that were given to small businesses during COVID. And so that money was not for the attorneys. The money was for the attorneys to be able to cover payroll and not lose their employees and not have the employees quit and go somewhere else. They were able to continue to pay their employees with that money. So anyway, that's it for me. Okay. So go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.